All right, I did look back. I know you were in front of Judge Scudder, and I had kind of questioned whether there was the perhaps ability for eviction defense screening line to be involved. It looks like that's not the case, but why don't the parties fill me in on where we're at?
So, Your Honor, obviously the first time we were in front of you on the 10th, we set it over for her to contact Northwest Justice Project. I was gone on the 17th, so it was set over to the 24th. At that hearing, I believe that was last week, she'd indicated that she was going to make an accommodation request. I objected as that doesn't provide evidence of a tenancy, which is kind of the issue that we're dealing with here. Judge Scudder set it over a week for her to file whatever she was going to file with the court, or for an attorney to file a notice of appearance. We don't have any notice of appearance filed. We actually have nothing filed since her original response. I received today to my office an accommodation request. It doesn't have any additional information that hasn't been presented to the court, and to my knowledge, it's not filed with the court. Ms. Craybill may correct that if I'm wrong.
I don't know if it got filed. I have a bench copy. I can't.
I got it. I got it turned in this morning, and then they had me take it down for you to have the bench copy today as well. I took the copy to her office last night, and she just was not there.
Okay. Go ahead, Ms. Kazmaier.
So my position, based on her response that's already filed and these new documents we received yesterday, that she's not established any evidence of a tenancy. This is an ejectment action. We're here on a show cause why a writ of ejectment should not issue. It's her burden to show that there's a tenancy. She's made a claim that there's a verbal agreement, and she's provided letters from her, I believe, counselors. They're not under penalty of perjury. They don't provide any evidence of any verbal agreement between her and Mr. Craybill. Mr. Craybill filed a declaration that there was no verbal agreement. And so, I mean, at this point, we're a month beyond the first hearing, which is a month beyond when this case was filed. She's provided no showing to the court that she is a tenant. She has had 4 weeks now to obtain counsel. They've not appeared, so we're asking that the court issue the writ today.
Are you taking any position on the ADA request?
The ADA request is tenancy relate. I mean, if she was a tenant and she made an accommodation request, obviously that's, something to consider. That's not really the issue we're here addressing. If she has to show that she is a tenant, and we don't believe she's made that showing, and we don't believe she is a tenant.
Okay, thank you. Ms. Craybill, did you reach out to eviction defense screening line?
Yes, I did. I spoke with Chasington, and he said that because of the labor for rent and because there was no actual rent given to the plaintiff, that I didn't fall under their legal aid. However, he did in fact write up the reasonable accommodation request for me and assisted me with that and let me know what I needed to do to prove to the court, which was collect the letter that is in the document provided from my counselor, from the New Life people that I work with, the medical letter from the pediatrician, and from my counselor showing that it is in fact dangerously and will impact my children's physical and mental disabilities as well as my own for being ejected. We are residents here. I've lived here for years. I have withheld my part of our verbal agreement. There's 2 different documents stating that the verbal agreement existed due to third-party hearing or communication, because I followed the New Life program for housing assistance, and I go to counseling regularly for my own mental health. I take medication. I did not include my medication list. I do have it present, but I figured that if you saw that you needed more information to prove said disabilities, I am more than capable of doing that. And if they refuse to go ahead with the reasonable accommodation request because I have been a tenant for so long, I will be filing discrimination, because that is what the attorney that I spoke with said was best for my children to obtain and keep their stability for their physical well-being.
So it sounds like there is one finding I can make at this point, which it appears now, we all agree that there was not a landlord-tenant relationship. Are you in agreement with that, Ms. Craybill?
Yes, we've always
Okay.
been family. When he made this verbal agreement with me, that was the first sign of any kind of agreement. I
Okay.
took it with good faith. I withheld every part of that. I've tried to prove through documentation through the programs that I work with.
Okay,
And
so that's okay. I just want to make sure we're all on the same page there. That's kind of step one. So then step two, and maybe Ms. Kazmaier, you want to answer this. How should the court view an ADA request? I know if we were in a tendency, it does impact the court's analysis, but how does it impact the court analysis, if at all, in an ejectment action?
That's a great question, Your Honor. I don't know that it does. I don't have any case law for you. I didn't brief that, but certainly if this is a court of equity, if Your Honor wanted to, stay the writ for 2 weeks, 30 days, something like that, to provide an equitable consideration for that. I don't know that there's any case law supporting that. If this were a tenancy as a landlord, I'm required to provide accommodations, but this is a situation where permission was given, that permission's been revoked. I think the law on that is pretty straightforward. I don't think that even comes into play here. But again, you sit in equity, so I'll defer to the court.
Ms. Faith Craybill, how much time do you think you need to find a new place?
I've currently been looking since January with the New Life program. I've listed what benefits I have available to me through the HRSN funding that's still available. With this reasonable accommodation request, it also brings that when I'm looking for new tenancy or new housing, I am not going to have a negative impact on my future of getting a place secured for my children, but a neutral one. As well as that, I like I said, I've been working so hard with the program. I have 4 different
Yeah,
applications.
so just slow down real quick. I just need to know how much time you're asking for under your reasonable accommodation request.
I simply asked until I could find stability and housing for my children elsewhere.
So if you're asking me to make an order in equity to find that because of the reasonable accommodation request and noted disabilities that you need additional time to find a place for you and the children, I can't leave that open-ended. So
I understand that, Your Honor.
What are you asking for? How much time are you asking for?
Like I said, I've been working since January. I have a couple of places I have already signed up and I have applications for right now. That I'm filing with New Life through their funding to try to get into these places. Like I said, it's really been difficult with this eviction thing pending. They always hear it and they immediately say, okay, we'll have a bad reference from the tenant, so obviously we're not interested. It's been very hard with my mental.
Okay, so how much time?
Your Honor, I honestly can't give you a designated time. I would appreciate as much time as possible just so that I don't have that stressful situation. I apologize for speaking fast. I'm trying to breathe. I do have anxiety and ADHD and stuff, so it's hard for me to focus at times. But I am doing the best that I can. I work, like I said, with New Life. You can see the multiple letters that they've vouched for me, that I'm working through their program. I don't know what a reasonable amount of time to ask for is. I never thought that it would come to this, being that we're family. He signed off as a witness for my marriage. I genuinely, I don't know what to ask. I don't know what's considered to be
Okay.
a fair amount of time.
Yeah, this has been going on for quite some time now, filed May 11th, so there's already been almost 2 months. So what I'm going to do, a couple things. I am finding at this show cause hearing that the plaintiff is entitled to possession of the property, that defendant has no interest in the property, and that the defendant is currently occupying the property without permission of the plaintiff. So I will sign an order for ejectment. However, I am going to stay it for 30 days until August 1st. I'm doing that in an equity position, given the reasonable accommodation request with some medical documentation that was filed today. And essentially what that means is it's about a 3-month time frame that's being given to move from the time that you were notified that the permission to stay at the property was being extinguished.
Your Honor,
So that'll be my ruling today. Yes, Ms. Craybill.
I was never given a time to leave this residence. I was never given a proper
I-
due process for eviction or any sort of
So
ejectment.
okay, so I am giving that today through the order of ejectment, and it will, after August 1st, if you have not left, then the plaintiff can have you ejected through the sheriff's office.
Your Honor,
Mhm.
I don't have a place.
I'm giving you 30 days, ma'am.
I can't guarantee 30 days I'll have a place for my
I-
children.
I understand.
I've been
Ma'am, I'm doing the best I can to balance homeowners' right to peaceful enjoyment of property they hold title to, and you who has given me documents that suggest you need a little additional time before being ejected. So I'm balancing those weights. Okay. So that'll be my ruling. Ms. Kazmaier, if you have an order that you could create and submit ex parte, granting but holding until August 1st.
Yes, I'll get that circulated to Your Honor.
Okay, Ms. Craybill, you got this, okay? You can find a place. It looks like from what you've submitted to me, you have lots of resources. You have people helping you. Please reach out to them, okay? Okay.
Your Honor, if per se, let's say I can't find a place as of August, I apologize. I don't mean to be emotional.
It's fine.
If I can't, like I said, I'm working to the best that I can in my ability to do so. If I can't find a place for my children with this in place,
Mhm.
if he is not willing to give more time, am I going to come back and I can ask for more time? I have to ask these things because I have 4 children under 4
I understand.
depending on me to keep
Ma'am,
these people.
ma'am, but you've been asked since either February informally or May formally through court proceedings that you needed to leave the house, that you're no longer welcome there. So I'm not going to give you further advice beyond that. I am going to go ahead and end the hearing. If you need to seek further legal advice, you can call back Northwest Justice Project, or legal aid. They may be able to assist you on how you would move forward if you don't have a place by the 1st, okay? Okay. All right, thank you both. You're free to log out.
Thank you, Your Honor.
Thank you.